credit to Justice Alito. I think it's a 10 out of 10. There are so many good things about his opinion. He goes through every conceivable basis for a right to an abortion in the Constitution and just dismantles that. We talk about the history. He mentions that the history cited in Roe was either wrong or irrelevant. And it's so nice for that to be corrected, because that's been a longstanding sort of annoyance and frustration of the pro-life movement, is the history in Roe was just wrong. He goes through every basis. He walks through stare decisis and shows why it's not compelling. He gives the standard as rational basis review, the same that applies to every other law, every other area of the law that's not regulated by the Constitution. And the states are allowed through the normal democratic processes to work through. And as Justice Ginsburg said, Roe halted that process by usurping the democratic role and arrogating that to the judiciary. One of my favorite things about Justice Alito's opinion is that he notes that 55% of voters in Mississippi are women. And so now those women actually have a say in what the abortion policy is in Mississippi. And so that's a huge win for democracy.
Howdy, everyone, and welcome back to Moment of Truth, the podcast of American Moment. My name is Saurabh Sharma. I'm the president of American Moment, and I'm joined by
Nick Solheim, the COO of American Moment.
And boy, do we have another special episode for you guys. I've started saying that we are the most unreasonably well-guested podcast in Washington, and I stand by that, because
so true.
We have a really, really special guest today. I think the first long-form interview she's done about this topic. We had on today Erin Hawley, who is a senior counsel with the appellate team at Alliance Defending Freedom, intimately involved with this Dobbs case and the overturning of Roe v. Wade. But before I get to the rest of that, as always, make sure to go to AmericanMoment.org. There you can find everything American Moment is working on to help train, identify, credential, educate the next generation of conservative staff who share our priorities about strong families, a sovereign nation, and prosperity for all. We have tons of programs going at all times. Right now, our Fellowship for American Statecraft is going on, but if you'd like to apply for a future round of that, you can always sign up for the interest list. We have AM Fridays, which are our intern trainings happening every Friday at the Monocle Restaurant. You can sign up at AmericanMoment.org/AM Fridays if you'd like to be getting the invitations for that. We have like 150, 160 people competing for just 70 spots every week. So it's a little bit of a rat race, but still worth putting your hat in the ring and trying to get in. We just wrapped, I think, week 5 of AM Fridays. And so we've got 5 more to go. So you can still hear from fantastic speakers like John Allen Gay, like David Goldman, like Zach Graves, and many others, people who've been a guest on this podcast, people who hopefully will be on this podcast at some point. And you can look at the backlog of this podcast. We have well over 60 episodes at this point, over 100 hours of incredible content with guests that have taken time out of their schedule to put together basically evergreen episodes that are really worth it and stand up to the test of time. If you're a staffer for a member of Congress and you think your boss can handle the hour in the chair, then send them our way, and we'll think about whether or not to interview them too. We've had some fantastic interviews with politicians lately, and so we're looking forward to doing more of that later this year. But enough with that. Today we had on Erin Morrow Hawley, who serves as the senior counsel to the appellate team at Alliance Defending Freedom. Before joining ADF, Hawley practiced appellate law at Kirkland & Ellis LLP, Bancroft LLP, King & Spalding LLP, all in Washington, D.C. Hawley has litigated extensively before the United States Supreme Court, as well as numerous federal courts of appeals and state courts of last resort. She has also worked at the Department of Justice, serving as counsel to Attorney General Michael Mukasey. As an academic, Hawley served as an associate professor of law at the University of Missouri, where she taught constitutional litigation, federal income tax, tax policy, and agricultural law. She also taught constitutional law as a senior fellow at the Kinder Institute for Constitutional Democracy. Her scholarship focuses primarily on federal courts and has been published in numerous top journals. Hawley is a frequent commentator on legal issues. Her work has been quoted or featured in the Washington Post, U.S. News, USA Today, Fox News, the Washington Examiner, the Legal Times, and The Hill, among others. Hawley has also written a book on motherhood entitled Living Beloved, Lessons from My Little Ones About the heart of God. Hawley is a former law clerk to U.S. Supreme Court Chief Justice John G. Roberts and Justice J. Harvie Wilkinson of the U.S. Court of Appeals for the Fourth Circuit. She received her bachelor's degree in animal science from Texas A&M University and her law degree from Yale Law School, where she served as a Coker Fellow in Constitutional Law on the Yale Law Journal. Hawley is an active member of the Missouri and District of Columbia bars and is admitted to practice before the U.S. Supreme Court and various federal courts of appeals. Her and her husband, Senator Josh Hawley, also have a fantastic podcast that they host together about their family and life and their faith and many other topics. What'd you think about all that, Nick?
It was a really amazing episode. While I was listening to you read the bio, I realized we never came back to the animal science. I had so many animal science questions.
Well, it was a touchy subject for me because she went to A&M and I didn't want our burgeoning friendship to be damaged by that.
Okay.
As a Longhorn, it was very unfortunate.
Yeah, no, I think what's so impressive about Mrs. Hawley is, you'll find a lot of politicians' spouses, men and women, come to DC and they get these sinecures, I think most famously with Dr. Jill Biden, who teaches at some community college or whatever. And what's so amazing to me is she's kind of forged her own path here and has now been a part of certainly the biggest Supreme Court decision of our generation. Mm-hmm. That is a huge accomplishment, and I've listened to their podcast, by the way. It's very good. I really like it. Mm-hmm. They're just incredible people, and I feel honored to have had her on the show.
Yeah, it was absolutely incredible. We'll go now to the episode. You guys listen to every second of it. It's fascinating. She's a true professor. She's great at explaining these really complicated concepts, and we learned a lot, and we think you will too. We'll go now to Erin Hawley. Mrs. Hawley, thank you for coming on the podcast.
Thanks so much for having me.
We always like to hear how our guests got to the point where they are today, and you're celebrating a lot of momentous victories over these last few weeks. But tell us the story of how you got to the point where you're involved in everything that you're involved in.
So it really is one of those sort of only God could have done this.
Yeah.
I grew up on a ranch in Northeast New Mexico and had always wanted to be a veterinarian. So went to Texas A&M, obtained an animal science degree, and it turns out I'm squeamish.
That would do it.
Yeah, so that does not bode well for being a veterinarian. And I'd always been interested in the law. I think particularly growing up in New Mexico, there are a lot of regulations that impact farmers and ranchers, and just seeing how those regulations are made, if it's at the administrative agency level or Congress, was really fascinating because they impacted people I knew deeply. So went to law school, ended up really enjoying it and becoming more aware at law school of also the religious liberty impacts that both the administrative state and also Congress, state governments, local governments can have on religious adherence. So that became very important. I ended up clerking. I clerked on the Fourth Circuit for Judge Harvie Wilkinson, and clerking for anyone that's in law school, definitely do it.
Yeah.
It is a fantastic opportunity to work. Usually there's 3 or 4 law clerks in a chambers with a judge. You get to work on incredibly interesting cases with someone who is almost always an excellent legal reasoner and writer with fantastic colleagues. So clerked on the Fourth Circuit for Judge Wilkinson, then went on to clerk on the Supreme Court for Chief Justice Roberts, who I respect immensely. Actually clerked, as you may know, with my husband, Josh. So that was a added unexpected benefit.
And were you guys married already at that point?
No,
or that's where you met?
Yeah, well, we'd met in law school, but not hadn't known one another very well. Mm-hmm. And so then we ended up clerking for the Chief Justice. Actually shared an office. Yeah. So the Chief's assistant credited herself with our marriage. She was the one who did the office arrangements. Yeah. But loved that year. And again, clerking at the Supreme Court is just a tremendous opportunity to get to work for an institution, a part of government, and see how it is that the law comes into being, to see, how judges are faithful or maybe not so faithful sometimes to statutory text and to the Constitution. And from there, went and worked for a number of different law firms. I had the chance, again, to work with really just impressive attorneys, and sort of an unsolicited career advice is just work for the best person you can.
Yeah.
There's nothing like being able to learn from someone who's, at the top of his or her profession. So I had the chance to do that for a number of years. I also taught at the University of Missouri taught everything from agricultural law to federal tax to constitutional law and litigation. And then while we were at the University of Missouri, my husband and I had 2 kiddos. So they're 9 and 7 now, 2 boys. And then we've split our time now between Northern Virginia and Missouri. Had our 3rd child. I'm still teaching some, working at a large law firm, and got to think, what really matters? I've only got so much time. I wanted to spend a lot of time with my family. So I've only have so much time to devote to sort of litigation and what is it that I can be doing that will make a difference. So ended up joining Alliance Defending Freedom. Had long been familiar with their religious liberty work. I think they've won an outrageous number of cases at the Supreme Court on really important issues. And it's just been amazing to be able to help with those cases.
Tell us a little bit more about what ADF does more broadly. I think if I were to put it in one sentence, it's like it is the white shoe law firm for social conservatives. Basically, it's massive. But what's the kind of scope of the work that they do, and what specifically were you working on while you were there?
Absolutely. So Alliance Defending Freedom has been around for a long time. And as you said, has sort of been the standard bearer for nonprofit law firms that are defending religious liberty. They have a number of different teams. They work a lot on school choice issues. They have a life team that was really involved in the Dobbs case. I know we're going to talk about. They have a legislative team that helps states out with pro-life or pro-school choice legislation. They litigate a lot of conscience cases. They currently have the 303 creative case pending before the Supreme Court. And this is the case that involves a website designer, Lori Smith. And Lori Smith is a committed Christian. She wants to make wedding websites, but wants to do so only consistent with her faith. And the state of Colorado actually told her, with the 10th Circuit agreeing, that if you are going to make a wedding website with your own creations, with your own designs, with your own words, you have to make it for same-sex couples in addition to traditional marriage. And so this idea of compelled speech, which is something the Supreme Court has been really clear on, everyone has a right to their individual beliefs and also to speak consistent with those beliefs. So there's a lot of really important issues ADF has been involved in.
Mm-hmm. It's amazing. Colorado just can't leave people alone, can they?
No, poor Mr. Phillips.
Yeah.
Yes.
Well, and it's amazing too. I think it's so, especially these days with how divided everyone is, it's so infrequent that someone will stand up for the little guy that's getting, punished for standing up for the things that they believe in and doing the work that they want to do. It's really rare to have someone on your side. I don't know. It's kind of refreshing.
Well, and ADF is not apologetic about who they're trying to defend either. I mean, there's a lot of law firms that would, be squeamish about the fact, we're defending Christians, we're defending social conservatives. No, they don't care. And that's why I've really enjoyed getting to know every single person I know over there. I'm curious, you've been in all of these, the top of the legal profession at every stratum, whether it was the law schools you went to, teaching, and then clerking. Let's take the precedent of Roe v. Wade and maybe the basket of sort of ridiculous precedents that were established mostly in the 20th century. What is the law profession at the highest levels view of those cases? What role do those cases play in their imagination? Because with the hysteria we've been seeing in the last few weeks, I think that's an underrated story, how permanent these things feel in their mind.
I think that's a really good point. And it's sort of a contentious point because those of us that have studied Roe, as you both really know well, I should say, there's no question Roe was wrongly decided. If you look to even liberal pro-abortion scholars at the time Roe was decided, John Hart Ely said that Roe was not constitutional law at all and barely gave any sense of an obligation to try to be. Larry Tribe has been really critical. Justice Ginsburg has been really critical of Roe. And so it's hard to find a serious legal scholar who will say Roe was rightly decided. But you're absolutely correct that it's become sort of this super precedent, some people would say, in the eyes of a lot of people. And I actually had a debate with a Columbia law professor last fall, and it was so interesting because the professor is pretty, very well respected, pretty middle of the road. He'd actually worked for the Reagan Justice Department when they asked the Supreme Court to overrule Roe in Casey and during that time period. So I said, I don't disagree with a lot of your arguments, but the Supreme Court will never overrule Roe. And, a couple of months later, the court did just that. So I think for a lot of people in the legal academy and the legal profession, the idea of overruling Roe was just unthinkable.
Are you a congressional office with interns this summer or an intern yourself looking to learn more about the America First agenda? Then you need to participate in AM Fridays, a brand new program by American Moment designed to teach young staff in DC the basics of what it means to be America First. Over the course of the summer, for 10 weeks, American Moment has rented out the top floor of the Monocle restaurant in Washington, D.C., and will be bringing in speakers from across the conservative movement to talk about issues from immigration to trade to foreign policy to innovation to how to support the family and much more. If you'd like your interns to participate in this program, email info@americanmoment.org with the subject line AM Fridays, and we'll be sure to add them to the list. Put that against the entire basket of precedents that weren't anything to do with constitutional law at all. I mean, what is the sense that you get culturally that elite academics and lawyers think about, whether it's originalism or conservative views of the law more broadly? Are they contemptuous of it? I mean, how does it play in their psychology?
I think there certainly is some contempt for originalism, this idea that you can be wedded to a theory that goes back to the 18th century and really take that seriously. I think there is a little bit of contempt. I've been grateful to see, Justice Scalia had a profound effect on the law. Justice Kagan, in one of her tributes to him, noted that we are all originalists now. Now, if you read the Dobbs dissent, that's not necessarily obvious. But I think it is true that post-Justice Scalia, we are in a world where the court and federal judges must take the text seriously. And this cannot be overstated, its importance cannot, because if we are in a world of a living constitution, we are in a world where judges can impose their own policy preferences, regardless of their very well-meaning views. If you are not wedded to text and to original meaning, then federal judges have the ability to make common law. And that means that unelected judges, rather than we the people, are deciding these issues.
Well, and I think that's what we saw and we talked a little bit about this with Josh Craddock a couple episodes ago, about how the liberal dissent was very much not rooted in like, these are in the Constitution, these rights. It was very much kind of a present day, current thing perspective.
The sweeping arc of history. Like,
what?
What?
It feels like a lot of it was kind of made up. But we spent a lot of that episode talking about Roe v. Wade specifically. And I think a lot of people, of course, like Twitter is not a place for nuance. So a lot of people are missing where this overturning of the precedent actually comes from in this case, in the Dobbs case. Yes. So can you tell us a little bit more, explain it to us, explain it to our listeners about what the case was, what ADF's and your involvement was in the case?
Sure, absolutely. To talk specifically first about the overturning of the precedent. So what the majority opinion written by Justice Alito decided was that the Constitution nowhere in its text, structure, or history contains a right to an abortion. And this is interesting because the Casey plurality, 3 justices, never went back and actually addressed the question of whether Roe was rightly decided. So Justice Alito does that, and he looks very closely at the 3 possible bases for a right to an abortion. He looks at the Equal Protection Clause, he looks at the right to privacy, and he looks at the Liberty Clause. The Liberty Clause is what most people have focused on. And the Liberty Clause doesn't, of course, explicate what rights might be included. So again, in those situations, we have to be really careful that judges are bounded by something, so that their biases and just unconscious preferences, policy preferences don't come through. So what the court has required is that in order for a liberty interest to be protected by the 14th Amendment, it has to be deeply rooted in our nation's traditions and history. And so Justice Alito catalogs the history and he says, look, there's absolutely zero evidence of a deeply rooted right to an abortion. He looks at the common law. Abortions were unlawful at the common law. They were criminal after quickening. In 1868, when the 14th Amendment was passed, it varies a little bit, but depending on your source, but approximately 30 out of 37 states criminalized abortion. No one disputes that 3/4 rather of the states criminalized abortion at the time period, and none of the states guaranteed a right to an abortion. So there's just zero historical evidence. So Justice Alito says, in light of that, there's no right to an abortion, and stare decisis, which is the idea that even if a case is wrong, then it's just better that it stands. I have a funny example of stare decisis. My first year of law school, my property professor was a bit nutty, and there were way too many students in the class. So students were literally sitting on the steps in this huge classroom. And so he comes in the first day and he didn't want any squabbling over seats. So he says, you each have a property right in your seat. He says, I don't care what you do. You can sell it. You can give it away. You can trade for notes. You can trade for pizza, cold beer. It doesn't matter. But we're not, and his point was sort of the stare decisis point. Sometimes it's really good just that the law be settled. And that way people can order their affairs. And Justice Alito really explained why that's not true in Roe. First, it has egregiously harmed the nation. It has disallowed states from protecting life, even at the standpoint of Mississippi's 15-week law. Babies at that point can open and close their hands. They have eyes and eyelids. They can hiccup, and they can quite likely feel pain. And yet the lower court said, nope, you can't protect them under Roe. As Alito said, it's also damaged the democratic process. It's damaged the court. And there aren't the concrete reliance interests that we require. So he said there's no right to an abortion, and stare decisis is no barrier.
So I think that's a really concise and clear explanation of what exactly Justice Alito ruled. I want to go back to the law that Mississippi passed, because there's sort of two elements to it. There's being good and just and right on its own terms, but there's also the element of legal strategy. And I know that these have been often somewhat private, rarefied conversations for the past 20 to 30 years, because it really did take a very careful stepwise process to get to this point. But I was hoping you could shed some light on what it was about the Mississippi law specifically that made people think this is the one, this is what we send up the chain. What did the law do, and why was it the right choice?
Absolutely. That's a great question. And I should mention that ADF, long before I arrived, helped Mississippi legislators with the law and drafted in with its passage. And I think the 15-week law was really ingenious for a couple of reasons. At the time in 2018, when the law was passed, Justice Kennedy was on the court. And Justice Kennedy had authored the opinion in Gonzalez versus Carhart, or Carhart 2. And in that opinion, the court had identified several interests that states could legitimately consider when protecting life. So those three interests were obviously the unborn life, also the health of the mother, and then third, the integrity of the medical profession. And so this 15-week law is really tailored to protect all three of those interests. First, as we've discussed, at 15 weeks, their babies have undertaken a tremendous amount of development. And Gonzalez, the court said that at 12 weeks, the baby has fully taken on the human form. You can see that in an ultrasound of a baby today. The health and life of the mother, abortion risk increased dramatically between the 8th and 18th week of pregnancy for women. So the Mississippi legislature noted those risks that increase with gestational age. And then finally, most abortions at 15 weeks take place through a procedure called D&E abortion. And this is dilation and evacuation abortion, which the baby is literally torn limb from limb and bleeds to death. And so the Mississippi legislature detailed this and said this was an additional reason to prohibit abortions. We don't want the medical profession to have to perform those sorts of things at this age. So those, I think, combination of factors that the court has said were important is why they arrived at the 15 weeks.
And so it was tailored to a court where Anthony Kennedy was still on, and also Ruth Bader Ginsburg. And so in your mind, would we have gotten a similar decision as we did today if the court had kept the composition it did at the time the law was drafted?
Absolutely not.
Okay. That's fascinating. And so what happened? The Mississippi law gets passed. What happens after that? What do the courts say in terms of immediate actions they take, and what do the conservative legal movement, Mississippi Attorney General's office and ADF and yourself start to think about in that moment?
So the Jackson Women's Health Organization filed suit the same day the law was passed.
Yeah.
So challenged it right away. I went to the district court, and the district court opinions in this case is worth a read. It's really dismissive of Mississippi's interest. It actually accuses the legislature of simply gaslighting about women's health and impugns really bad motives to the Mississippi legislature.
District Court.
Yes. Yeah. Federal district court. Yeah.
In a state like Mississippi, you would assume conservative judge or something like that. No.
Nope. Not in this case.
Yeah.
So it goes up to the Fifth Circuit. And interestingly, the Fifth Circuit also strikes down Mississippi's law. And they say basically that their hands are tied, that under Roe and Casey and later cases, states cannot protect life until viability, which is about 22 weeks. So no matter what science says about a baby's development, no matter how compelling a state's interest in life or medical profession or health of the mother, no dice until 22 weeks. Judge Jim Ho writes a really good concurrence in which he says, my hands are tied by Roe, but Roe was wrongly decided. And then comes a really interesting part of the case. The Mississippi petitions for cert, which is an ask of the Supreme Court to take the case and to review it. And the case sits on the docket for about a year.
Wow.
Which is really unheard of. It just kept getting rescheduled and rescheduled and rescheduled.
And this would have been between what window of time? So
it would have been, April of 2020, I believe, through almost that next year.
Okay.
And in the meantime, Justice Amy Coney Barrett is nominated and confirmed, which, as you suggested earlier, is a huge shift in views on abortion from Justice Ruth Bader Ginsburg to Justice Barrett. So after Justice Barrett is confirmed, the court goes ahead and grants cert in the case. And that means that at least 4 justices voted to hear the case. And one of the interesting issues in the case is that, Justice Ginsburg was on the court at the time period when Mississippi petitioned for certiorari and asked the court to hear the case. And so Mississippi's cert petition pointed out both that Roe v. Wade was wrongly decided, and also that the 15-week law, should be upheld regardless. So sort of 2 grounds there. Then the Supreme Court grants cert with Justice Barrett. So there's a real strategic decision to be made at that point by Mississippi. Do we sort of ask the court just to uphold our law, just to uphold Mississippi's 15-week law, or do we say, we actually need to overrule Roe versus Wade?
Yeah. And so you guys, it seems like, took the latter to overturn Roe versus Wade. Walk me through, you've said the party that was bringing the suits against Mississippi was the Jackson Women's Health Organization. What's the other side of that coin? What are the entities that at that point are activated to defend Mississippi's law? How are others able to help? What's the actual, who's involved in bringing this case forward? Yeah.
Absolutely. So there's a whole host of interested pro-life organizations that served as amici in this case. I think there were 81 amicus briefs on the pro-life side, which is amazing, the most ever. And also the first time that there have been more pro-life amicus briefs than pro-abortion briefs. So that was fantastic. And one of our vice presidents, Brett Harvie, coordinated that effort. So that was fantastic. And then ADF has, as I mentioned, worked closely with Mississippi since the law was drafted and passed. And so a team of us went down to Mississippi in April of last year, and we're able to visit with them sort of about strategy and those sorts of things. And this trip is really special to me because at this time our now 20-month daughter, Abigail, was 6 months old. And so ADF is really great about allowing attorneys to bring their babies with them if they're little. So Abigail flew down to Mississippi with me. We had a layover in Atlanta, and we arrived. She was exhausted and angry, and my babysitter wasn't there yet. So she goes to this meeting, and we're trying to discuss what's the best strategy for this case, and what are the individual justices' views. At that time, a lot of people didn't know what Justice Kavanaugh might think about abortion. He hadn't had many cases at the D.C. Circuit. Everyone knew Justice, I should say, Barrett is pro-life personally, but will she go all the way in Roe was a big question. So just thinking through all of those sorts of issues, and Abigail was asleep in her stroller until she wasn't, and she screamed really loudly. But there was also something really special and kind of tangible about the fact of having Abigail with me. at the time we're considering this case that might have the potential of overruling Roe versus Wade and allowing every state to protect Abby. And I've said it before, but she's gorgeous, of course, because I'm biased. But she's curly-headed and round-cheeked. But at the same time, she's not any more precious or any more loved by God than any other baby. And so this Dobbs decision had the potential at that point, and we've seen it today, to allow states to protect every child. And so that was really neat to be there discussing Dobbs with Mississippi, with Abigail.
Yeah, it's a unique sort of moment, right? Because, some narrow, wonky admin law case, it's very abstract. You don't see it, and, had to have been very personal for everyone involved.
Yeah, this is one of the things that I told my wife. Let's see, it was last Friday. Has it only been a week?
Yeah.
Holy cow.
Yes.
But when I went home last Friday and talked with my wife about it, she's 22 weeks along now. And I told her, I said, I feel like, and we're also having a daughter, I was like, I feel like, when Jesus and John the Baptist were leaping for joy in the womb, and my wife started crying. I'm sorry for exposing you like this, but, it's really exciting to think about all the people that, my daughter will be friends with that may not have existed otherwise. I think something worth touching on is the difference between the Mississippi law and laws in other states, like Texas, I think is the other one that's most frequently talked about. What made the case in Mississippi so special? Like, why was it not the Texas case that was the one that went up to the Supreme Court?
So the Texas case took place after Mississippi. So Mississippi had already granted cert in that case. And the issue before the court in the Texas case was sort of a procedural one about, can states direct certain litigation to state courts first and that sort of thing. So the challenge there, because of the way the law was structured, was actually to the procedure.
Gotcha.
So here, the real question was, does Roe disallow abortions all the way up until viability? No questions, no considerations the state can have would matter. And that's one thing I really commend Mississippi on. As I mentioned, we went to Mississippi. I was able to help them throughout the case. And one thing they were always really clear on is that we represent the people of Mississippi. And the people of Mississippi want to protect life. And so we're not going to take some middle ground and just go for an incremental approach. We're going to ask the court to overrule Roe. It's absolutely wrongly decided. The people in Mississippi think it's wrongly decided. And we should ask the court to do the right thing.
Yeah.
Well, it's a relatively ballsy thing to do too for a small state. And actually, we've seen this twice with the we saw it too with this West Virginia versus the EPA, where some of these smaller states. I just bought a house in West Virginia, so I'm like,
love it. Yes.
Very, very excited about this. But where some of these smaller states will basically look at the federal government and spit in their eye and say,
no, you can't do that.
Yeah.
Final question, just on the particular reasons why this was selected. Was there a major difference, you think? Certainly at the time, a very small C conservative approach would have made sense, especially with Anthony Kennedy still on the court. But do you think if the case that had gone up to the court had been, say, a challenge to a heartbeat law or something, do you think we would have gotten a meaningfully different result? Or just curious as your game theory on that.
That's a good question. So I'm not sure. The court was really clear, which I find so heartening, that Roe versus Wade was wrongly decided. You've got 5 solid votes for that. And so I would hope their decision wouldn't matter based on the law. Roe would be no more rightly decided if you're looking at a 6-week law than an 18-week law. Or 15-week law, I should say. One thing that's interesting is that the viability line, again, 22 weeks or so. I think some babies have survived at 21 weeks. But a number of states have passed pain-capable bills at either 20 weeks, some at 18 weeks. And a lot of those bills have not been challenged. I think on the idea that maybe Planned Parenthood and others thought, maybe, it's pretty hard for courts to say, a baby can feel pain, and yet still states can't protect them. So they did challenge the 15-week law, but we're not challenging pain-capable bills around 20 weeks.
Interesting. And just minor thing, was that center that challenged the law, is that a Planned Parenthood affiliate or just an independent abortionist? Or
I should know that. I'm not sure, actually. Yeah, it's the only abortion clinic in Jackson, Mississippi, but I'm not sure.
And has it been torn down? It's gone now?
I don't, I'm not sure.
Yeah. So now going to this final stage of the process where the case was before the court, the arguments have been decided. You've been on the other side of the picket fence, so to speak, inside the Supreme Court itself. I'm very curious what your kind of read of what the atmosphere when a case of such importance comes before the court. What's that like inside the building? And I'm sure that I'd be curious as to your thoughts on the leak and everything as well. But what do you think it was like there when, basically 50 years of super precedent was at risk of being overturned? I mean, how would you imagine that conversation went internally?
It's a great question, and to be clear, I don't think there is such a thing as super precedent. But Justice Breyer might. And so I think one thing I was encouraged by is not too long ago, Justice Sotomayor was giving a talk and complimented Justice Thomas. Very well deserved compliments. Justice Thomas knows the name of everyone in the building. He knows about their families. He knows about their kids. He asked, how's your son doing in college? How's your daughter doing with, whatever ailment? So she went ahead and went out of her way to compliment him. So I'm hoping that means that the court is still collegial. It certainly was when I clerked there in 2007. And we had some big cases. We had Heller and some other cases that provoked tensions. But I think Roe was unique. And I think we saw from the leak that tensions were especially high at the Supreme Court. The leak was egregious. There were a few outlets that seemed to say, this is ordinary course. It's happened before, but that's simply not true.
Yeah. As a clerk before, I mean, would it even have occurred to you to do that? Oh my gosh,
absolutely not. No, we were terrified. In fact, as a clerk, one of the sort of nice things is you get to take the other justices to lunch, which means you take them to lunch and pay for their lunch. It's kind of a funny setup. But during those conversations, sometimes you would be at a restaurant not too far from Capitol Hill, and the justice would want to engage in conversations about a case. And as clerks, you're like terrified, like someone might overhear. So no, absolutely. I think it is a tremendous, honor to work at the court as a clerk, and there's a sense of trust. And no, I can't imagine most people would ever consider something like that.
And do you think that trust is kind of permanently broken because of what's happened?
I hope not. It's certainly damaged. Because again, nothing like that's happened before.
And so, these arguments are brought before the court, and that they're engaging in deliberation. When the leak happened, what did you guys think? Do you guys think that the leak changed anything about the final opinion that you got? How were you guys thinking about it at the time that it came out? I mean, it's got to have been, of all the planning you could do, that's the kind of wrench that you wouldn't even anticipate. I mean, what was that day like for you guys?
Yeah, so absolutely a shock. I think to everyone involved in the litigation, a good shock in the sense of we knew that at least initially there were 5 votes. It came out
in like an evening on a weekday too, right?
Yes.
So you were probably just scrolling on your phone and suddenly the notifications.
Your phone blows up. And so we knew there were 5 initial votes to overrule Roe. Didn't know where the chief was at. Pretty certain that there were 3 dissents. But again, as Mississippi said at the time, we just await the Supreme Court's opinion. So as a litigator before the court, that's really all you can say. You're hopeful that the draft opinion or the final opinion will look a whole lot like the draft opinion. But I think, shocked at the leak, encouraged by the initial votes, hoping they would stay the same. And I think the Chief Justice had a really good response when he said, the court will go forward to do its job. This leak and intimidation won't change our process at all.
And what's that process like of an opinion being generated inside the court? Again, this is something you have unique insight into, having clerked there. How did these things come about, just for our listeners?
Absolutely. So after the Supreme Court hears oral argument, which it did in Dobbs on, I think it was a Wednesday, December 1st. So that Friday, December 3rd, the court would have gathered in a conference room, just the justices. They would have discussed the case and took an initial vote. The justice in the majority would then have had the opportunity, the most senior justice in the majority, so the longest serving, would have had the opportunity to assign that case. In this case, the decision was assigned to Justice Alito.
And who would have done that assigning? Would it have been Justice Roberts or Justice Thomas?
I think it would have been Justice Roberts because it's a vote to affirm, although, on possibly more narrow grounds for the chief. And so Justice Alito would have taken that opinion, went back and spoken with his clerks, and they would have dived in and, spent, they were already very familiar with the case, but dived into all of the cases, started writing and drafting. From the leak, we know that an opinion was circulated from Justice Alito's chambers in February, and that goes out to all of the justices. The best thing you can hear as a law clerk working for a justice is just two words: join me. And that means that another justice has joined the opinion without any requested changes. More often than not, the justice will come back and say, could you change this wording or that wording, or I'm not sure I quite agree with the way you characterize that case, or, what about this argument? So there'll be some back and forth, even among the justices who agree with the decision and most of the writing. You might also see concurrence circulating. As in this case, we know Chief Justice Roberts has a concurrence, Justice Kavanaugh has a concurrence. And then at some point in that process, you'll get a dissent. And the dissent will circulate, then the majority will respond to the dissent, and back and forth until they get the final opinion.
And so walk us through those concurrences, both Justice Thomas's, which seems to maybe go further than the opinion, and then Justice Kavanaugh and Justice Roberts's. What do you think Justice Roberts and Justice Kavanaugh's holdups were? What were they trying to say in those concurrences that the majority opinion did not capture in their view?
So I think the great thing about Justice Kavanaugh's opinion is he joins the majority opinion in full. So it is clear that states have the authority to regulate abortion, and that those laws are subject only to rational basis review. So that it gives states a lot of authority to protect life. As Justice Alito says, it's a legitimate interest to protect life at all stages of development. So that is a huge, huge development for pro-life states. Until last Friday, states couldn't protect life until 22 weeks. Now they can protect it much earlier because of that standard. Justice Kavanaugh goes on to sort of mention some of the areas that might come up. He talks about interstate travel, and he doesn't think states would be able to forbid someone from going to a state to obtain an abortion. He talks about a few things like that, sort of laying out some different wrinkles. Justice Thomas talks about his long-standing position on the due process clause. He says, it's an oxymoron. It's not the substantive due process clause, it's the due process clause. And I think he would root some of these rights, not abortion, but some of the rights that we see coming out of the due process clause in the privileges and immunities clause. So he would sort of reconceptualize how it is the court goes about these sorts of inquiries as an original matter.
And we saw a lot of belly aching about that in some of the other cases that he mentioned, like Obergefell.
Sure.
How likely do you think something like that is? I mean, as far as I can recall, I don't think any other justices joined his concurrence. So how likely do you think something like that is?
That's correct. No other justice joined Justice Thomas' concurrence, and the majority was at pains. I think it's 3 or maybe even 4 times. The majority points out that abortion is different from all of those other cases. It's different than contraception. It's different than marriage for 2 reasons. And first is that abortion takes the life of an innocent third party. So there's no other case, no other right the Supreme Court has recognized that allows for the destruction of a human life. So the court says that again and again. They also mention that the analysis was Roe rightly decided, and then what about stare decisis? And Alito points out that stare decisis might be different for those other cases as well.
Interesting. In the range of possibilities with the court that we have now, of what the opinion could have been, I mean, there's a world where a much narrower opinion, much like the Roberts concurrence, comes out. Is there a world where there was anything much better? Was this a 9 out of 10, 10 out of 10? How have you thought about, on the scale, I guess, how well you guys did your job? Yeah.
So I really think, credit to Justice Alito. I think it's a 10 out of 10. There are so many good things about his opinion. It goes through every conceivable basis for a right to an abortion in the Constitution and just dismantles that. We talk about the history. He mentions that the history cited in Roe was either wrong or irrelevant. And it's so nice for that to be corrected, because that's been a longstanding sort of annoyance and frustration of the pro-life movement, is the history in Roe was just wrong. He goes through every basis. He walks through stare decisis and shows why it's not compelling. He gives the standard as rational basis review, the same that applies to every other law, every other area of the law that's not regulated by the Constitution. The states are allowed through the normal democratic processes to work through. And as Justice Ginsburg said, Roe halted that process by usurping the democratic role and arrogating that to the judiciary. One of my favorite things about Justice Alito's opinion is that he notes that 55% of women voters of voters in Mississippi are women. And so now those women actually have a say in what the abortion policy is in Mississippi. And so that's a huge win for democracy.
Yeah, absolutely. What do you think this opinion says about the long history of legwork done, I guess, by the conservative legal movement to maybe right the excesses of the Supreme Court in the late 20th century? Does it feel like this is the end of the beginning? Are we just getting started? I mean, how are you thinking about maybe that grander timeline for writing our jurisprudence?
I think there's just a huge thank you to so many people who've worked tirelessly, academics, but especially the people that have prayed and marched and just, told their state legislators we want to protect life over and over again, even as federal courts struck down law after law after law. And so people, as you said, have been engaged in this effort for decades. And there's also been a lot of legal groundwork. I mentioned that even Justice Kagan said we're all originalists now. And it's a huge shift. If you go back to look at a constitutional decision written in the 1960s or the 1970s, sometimes the text of the Constitution may be mentioned in the last paragraph or maybe not at all. And so it is really democracy reinforcing that the courts today look at the text first. They may not always adhere to it, but at least under current doctrine, they're forced to confront that. And as Justice Scalia said so capably, that means that we're governed by our elected representatives and not by 9 judges.
Yeah.
So with things like the Kavanaugh concurrence where he's talking about, potentially having a law against traveling across state lines to get an abortion, where does the pro-life movement go next? I mean, not just state level, but nationwide.
So I think right now we are seeing a rash of challenges to state laws. And there's a couple of categories of state laws. There's what are known as trigger laws. So these are laws that states have passed basically saying, we know Roe says we can't protect life, but we really want to. We as citizens think life is important in this state. And so if and when Roe is overruled, we'll have this trigger law that will come into effect. So there's that category of laws. There's also categories of laws that predate Roe. So a number of states have laws that were on the books before Roe. The state legislatures never got rid of them. They still believed in life. So those laws are on the books. And then there's also state laws that are enjoined by federal courts. So states have been going in and asking federal courts to undo the injunctions. I think Alabama actually got one on Friday, which is fantastic. So I think they were the first state. And then, but we see a rash of challenges in Michigan, for example. ADF has intervened to help defend a pro-life law that the governor says is no longer valid. Different pro-abortion groups have filed suit all over the country to challenge these laws. So I think that's really the first sort of battleground.
Aren't there liberal states that have abortion bans on the books that they never undid in statute that just got overturned by Roe v. Wade?
I think that's possible. I'm not aware of one. A lot of the really pro-choice states in the recent months have been doing just rafts of really liberal legislation. So you saw a bill in California, for example, that permitted even perinatal deaths or forbid inquiry into perinatal deaths defined to include 7 days after birth, which is just crazy. So a number of the states have gone even further. There could still be a blue state out there with a good law, but I'm not sure.
And that was the point of the leak, right? Is to give these states time, especially so that it didn't become as much of an election issue, getting closer and closer to the general election, which is why it's such a horrific usurpation of the rule of law for that leak to have happened. How are you thinking about the court's appetite for more litigation? I mean, it seems like Justice Kavanaugh wishes that another life-related case never comes to the court again. Do you think that's accurate? I mean, do you think that there's going to be challenges all the way up to the Supreme Court on major life-related legislation in the next couple of years?
It's possible, some of these wrinkles, but it's also possible the courts of appeals could handle a lot of them. I think if the court would have taken a middle ground, for example, and adopted Chief Justice Roberts' reasonable opportunity to obtain an abortion, what does that mean? We don't know. So that case, or if an opinion like that, a case would have ended up at the court in no time flat. So I think this case does the best, or the Dobbs majority does the best job it can of signaling like this is an issue for the states. It's subject to rational basis review. That gives the states an awful lot of authority and ability to protect life. There may be some lower court judges who protest and find ways to stop these laws, but overall, you've got a lot of authority for the states.
In the days after the opinion, there were clips going around of AGs signing stuff. I think your home state attorney general did something. What was going on there? What were they exactly doing? What was the role of the AGs that suddenly after the Roe decision?
So a lot of it was trigger laws.
Okay.
And so this idea being some states have requirements that the AG must certify that Roe in fact has been overruled, which it clearly was in the Dobbs decision. And so that starts the time period in which the trigger law can be enforceable.
So what do you think liberal forces in American life are going to do next? I mean, do you think they're going to keep trying to take stabs at the Supreme Court? Do they recognize that that's sort of folly? I know a lot of them are talking about packing the court. What do you think their next line of attack is going to be? Because for the first time, it feels like in 60 years, they're on the back foot and they are now in the position we were in 50 years ago.
Well, it's really nice because those who are advocating for pro-abortion stances really now have to advocate against democracy, which is kind of a tough position to be in.
Yeah.
So I think that is just a huge righting of a wrong. Roe took that out of Democratic hands. Here we have it returned to the states and to the people. And this idea we've heard talk about the Biden recommended that the filibuster be done away with so that they could have federally enforceable abortion rights and those sorts of things. I don't think that will fly, either the filibuster or federal abortion rights.
The window of time that you were in law school, a clerk, and then teaching law was, I think, the period of time where originalism kind of became the thing that legal academy couldn't ignore anymore. How do you think, especially with this case that is so central in the mind of the liberal jurists in America, how do you think this is going to change the culture of the way that constitutional law is taught in law schools? I took a couple classes in undergrad that were basically identical to intro con law seminars, and it's very interesting, this weird position that law professors have to take. I had a liberal law professor who, unfortunately, there was no way for him to teach con law except on originalist terms, because you start at the beginning, and at some point it's funny. I have these concrete memories of basically going through the case history across a variety of issues, and at the end of every case he'd ask the students, would you vote to overturn this law, or would you vote to keep this precedent? And there was just so much drop off over the course of the semester that by the end there were like only 2 students in the class that actually thought that any of our existing precedent system makes any sense whatsoever. How are you thinking about how legal academy is going to change based on this?
That's a really good question. My fear is that if you read the dissent, it is really a full-throated endorsement of living constitutionalism. And the dissent forthrightly admits that in 1868, which is the relevant time period, there was no deeply rooted right to an abortion. But they say that doesn't matter. And that is really astounding to say that a court can take a liberty interest, divorce it from history, and come up with a right that the framers of the 14th Amendment never would have imagined. So that idea of living constitutionalism, I imagine you'll see some academics sort of trying to buttress that type of thing. I think it's a tough argument to make, again, because as so many others have pointed out, if you do that, then you do really leave it up to 9 justices. And that's difficult to think. Alexander Hamilton famously called the Supreme Court the least dangerous branch. And yet if we take living constitutionalism seriously, the court has the final say on so many issues. So I think that's what we'll see. We'll try to see the buttressing of living originalism, or living constitutionalism, I should say. But yeah, I hope that effort is unsuccessful.
So you mentioned at the beginning of the episode that you and your husband met, while clerking at the Supreme Court. Did either of you at the time believe that, within your lifetimes we would see this decision made?
There was certainly hope, because you'd had great opinions by Justice Scalia. You'd had great opinions back in the day by Justice White. He called it a raw exercise of judicial power that was quoted in Justice Alito's opinion. You had, Justice Scalia, Justice Thomas. You certainly had some really heavyweight judicial and academics pointing out Roe's flaws. But it was, I think, sort of unthinkable. But the places we went to law school and those sorts of things, the idea that Roe might seriously be reconsidered, I think was unthinkable.
What have you made of kind of what the left has been doing to the justices? Again, having been on the inside of that system before, it's just it's got to feel like such a new day and in the norms of this country. What do you make of the intimidation going on?
It's absolutely horrible and it's illegal. Like the Justice Department should enforce the law, which plainly prohibits attempting to influence a pending case, which was clearly the case before Dobbs was decided. I remember Justice Souter used to, walk over to a bakery from the court, and it's unconscionable that justices can't do that nowadays without fearing for their lives and safety to protest at someone's home with young children, like they did Justice Barrett. That's really unconscionable and should be is illegal, should be enforced.
So I'm going to ask you to make some predictions. What do you think the landscape of the legality of abortion looks like by 2030? I mean, or maybe even shorter time horizon, 5 years from now. How do you think this is going to settle when states are actually given the chance with the political climate we have right now to decide these things democratically?
I'm hopeful. We're already seeing some states are going to be really pro-life, which is huge. We're also going to see some states, a number of state courts have found state constitutional rights to an abortion, but like those, Florida's a good example. Those are based on the federal constitution. They decided on the state constitution, but all the case law is federal. So those decisions will be reconsidered.
Say a little bit more about that. Do they have like their equivalent to the 14th Amendment, and it was interpreted similarly to the federal constitution, so now that needs to be wound back? Or
yes, exactly. Okay. And in Florida in particular, it's a right to privacy. The Florida Constitution has a right to privacy, and they look to Roe and say that right to privacy includes a right to abortion. But they don't look actually at what the Florida Constitution means. So I'm hopeful that Constitution, as well as others, will be revisited. So you'll see some states, state legislators that are allowed to protect life when those bad Supreme Court decisions go to the wayside. I'm also hopeful, and this may be more of a stretch, but one of the things the Chief Justice mentioned in oral argument is that American abortion law under Roe is less protective of life than all but a handful of countries in the world, and actually 6. And the United States is in the same company as China and North Korea in allowing abortions up until the moment before birth. And some of these liberal states have passed laws in the last few months allowing that. So my hope is that, once maybe the political dynamic of Roe, it's recognized that Roe is overruled, that even some of those liberal states will reconsider some of those policies and decide that life deserves more protection.
We should do like a man on the street thing. Like we should go out in front of the Supreme Court and ask people like, who do you think has laws like the United States on abortion, and then just hold out the microphone.
Or show them an ultrasound. It's amazing. There's a great brief in the Dobbs case, and it shows an ultrasound in 1973. And, you really can't see much.
Just smudges, yeah.
And then they show an ultrasound today at 15 weeks, and the baby is clearly visible.
Well, it's amazing. We had our first at 12, I think, 12 weeks. We found out really early on because my wife was extremely sick immediately.
It's awful sometimes.
So we knew pretty early on. And showing it to, I remember the first time I showed it to you, people point at it and they're like, oh, that's the head, that's the feet. Cool. It's 12 weeks old and they're like, oh yeah, I know exactly what that is. It looks like a person.
Absolutely.
Yeah. The technological side of this is so interesting. And I think ultimately it's going to be the leading indicator for where culture and law both go, is both as fetal viability, the age of fetal viability just plummets, as it will with medical technology as time goes on, as what is happening inside the womb becomes so much more clear. I think that this is one area, and there's not a ton, where technology truly just is going to be helpful for our side. The veil of ignorance is so much of what the left has to rely on in order to have the laws that they do. And it's why they get very upset when you explain what the abortion procedure is. It's why they get very upset when you describe what a baby is like developmentally at very young ages. I guess that's the next layer to this, is what do you think the cultural, sociological outlays of this are going to be? I mean, it's gonna scramble a lot of the way that people just go about life in the United States in terms of how they interact with other sexes and, the sexual revolution, all those elements too. What's your predictions there?
So I think the immediate effect of Roe will be that we'll have more babies who are born. And I think that's a huge sort of rallying cry and responsibility for the pro-life movement. There's thousands of pro-life centers currently that do a fantastic job, but we've got to go do even more. There's one study from the Human Coalition that shows that some 75% of women who end up having abortions say they would have chosen life or to parent if their circumstances would have been different. And we just have to change that. We have to be a culture that promotes life when in the womb and beyond, and really come alongside these women.
There's kind of concern trolling that the left likes to put forward is that, oh, you're not pro-life, you're pro-birth. And I have always found myself in a funny position because even though I have all sorts of heterodox views on economics and what maybe government can do to help families thrive. Like I want to defend the right of even a pro-life libertarian who doesn't think the state has those roles to be pro-life. Like it's wrong to kill babies, full stop, period, bad. But what do you think some of the next stages of the pro-life movement are in terms of creating an America that is more friendly to children? Obviously, the most extreme version of unfriendliness to children is killing them. But what do you think some of those next steps are that you're excited to see the pro-life movement maybe start to refocus its attention when it's kind of done the cleanup and it's like, okay, we've banned abortion in this state. We have a thriving pregnancy resource center network. What else should they be working on?
Well, the pregnancy resource centers are going to be overwhelmed. So they're going to need more help, more resources, more time. I love the quote. I think it's by Mother Teresa that says, I can do what you can't and you can do what I can't. And so this idea that we all have something to contribute, whether it's our time, whether it's volunteering, whether it's financial resources. I think churches have a huge part to play. They can start preschools. The church we attend in Missouri has this great preschool that's located in a lower income area and it's free. It's just this wonderful opportunity for families to have a great preschool that's provided by the church. I think we're going to need to see Texas has some great programs. It's both public and private. They've got fathership initiatives, fathership classes. They really encourage the dads to take part in this as well as, it takes two. And in addition, they've got educational programs for expecting moms. They've got job training programs for expecting moms, and really just this whole panoply of resources to come along. So I think, churches definitely have a role to play. The pro-life community definitely has a role to play, as well as government.
And looking at the future of, social conservatives that are involved in the legal profession, what do you think some of the next fights on that front are? Because, the pro-life movement more broadly is going to have plenty to do, but for people who are lawyers with lawyerly things to do, what are the next couple of fights on the horizon? It looks like we have a court that's eager to impose sanity, or at least will do so if you drag them kicking and screaming. What are some of the other cases that you're hoping the court takes a look at?
I think just out of the abortion context, we're going to see the administrative state sort of come into high gear. Already HHS and President Biden have suggested that there's a role for the federal administrative agencies to play in the abortion context. And so I think that's a huge question, both from a sort of normative perspective and then also as it applies to abortion. There's this huge question as to whether administrative agencies should be making decisions, imposing cap and trade on the country. In West Virginia versus EPA, the court said no. That's the major question. If Congress is going to delegate that to an agency, and there's a big question as to whether they can. But if they're going to, they need to say so clearly, which they didn't do in West Virginia versus EPA. Arguably the same thing with abortion. If you're going to, say that the FDA can regulate abortion, certainly we would think that Congress would have to say so clearly. So I think those sorts of issues are going to be sort of front and center. The power of the administrative state, if there's some limits to what Congress can delegate, those sorts of things as well. Religious liberty issues. ADF filed an amicus brief in a school choice case called Carson versus Mencken, which was a huge win for school choice. And in that decision, the Chief Justice said that the state of Maine, it has a very rural school district. So a number of the public high schools a number of the school districts don't have public high schools. So they say you can send your kid anywhere. You just can't send them to a religious school. Or at least a school that's too religious. Like you can be religious in name only, but you can't actually teach religion. So the Supreme Court said, no, that's discriminatory. But the state of Maine doubled down. And the Attorney General issued an opinion and said, actually, you can't send them to a religious school if they have traditional views on marriage. So we get to
the rub. That's what they're actually after.
So those fights are on the horizon as well.
Yeah. Yeah, it's pretty funny to see, them show their cards and say what they actually mean on this stuff. I think I also saw something crazy that the Biden administration is talking about. Oh, federal enclaves can like put up abortion pickup trucks or something crazy like that.
Yeah, you can do it on like military bases or on like Native American reservations or whatever.
Yeah.
That's what they were saying.
And I think there's serious legal problems with both of those. But I've seen those theories.
Yeah.
So the fight is not over. So you would no one can rest on your laurels. Ms. Hawley, where can people keep up to date with what you're doing? You're not on social media, which is good for all things considered. But where can they keep up with your work, ADF's work, and where should they be paying attention in the months and weeks to come?
Absolutely. Really encourage you to go to adflegal.org. It's got information about the Dobbs case, but also a whole host of other cases that ADF is involved in.
Wonderful. Well, thank you for taking time out of your very busy schedule and very sudden media frenzy. And thank you for everything you've done for this case and everything else. I think the country thanks you for it too.
Well, thank you. It's great to be just a small part.
We told you guys that would be very special. Thank you again to Mrs. Hawley for taking the time out of her busy schedule to come on. She's had to do a lot of media all of a sudden. ADF was quite circumspect about the role they were playing in this process until about now. And so it's been really exciting for them to get to take a little bit of a victory lap. It's a lot of hard work, a lot of people, and by no means not just her. And she emphasized that point many times during this episode. She played a small part in what was really 50 years of hard work, but an important part, I think. And thank you to her for coming on and everything that she does for the conservative movement. As always, check out the backlog of this podcast and rate and review it 5 stars. It really does help us in the rankings. It helps us get on incredible guests like Mrs. Hawley, and will help make sure that we can continue to bring this podcast to you for months and years to come.
I'm just remembering the review that you read like a week or two ago where the person commented, "I like podcasts."
Yeah. The thing that you don't know about it is that the person who commented "I like podcast" will actually be on our podcast soon.
Oh, really?
Yeah.
Okay.
I'll leave it up to the viewers to guess who that ends up being. But it should be a good one. Yeah, we get a lot of very kind and very funny reviews, often in the same, sometimes different. So make sure to do a good review, and we might read it out on the show. Anyway, guys, thank you so much for listening. As always, we're very grateful that you guys tune in every week and hear what our guests have to say and what we dum-dums have to ask them. We'll see you guys next week. Moment of Truth is an American Moment Studios production filmed at the Conservative Partnership Center. Our podcast is produced and edited by Jake Mercier and Jared Cummings. Our intro music is A Minor Struggle by Ryan Serenich. Don't forget to like and subscribe on all platforms, and you can go to AmericanMoment.org to learn more.